as you read through the rest of the summons and determine for yourself that it mainly repeats in many different ways that you owe the debt, you may get to the end and find something surprising. You remember back a couple of videos ago when I was talking about debt collectors sometimes saying to you, if this account goes to legal, you won't be able to settle anymore, and how I said it's not true? Right there in your court summons will likely be several pages on what's called alternative dispute resolution. I've included copies of the actual ADR forms that came in my summons, and in your jurisdiction, you should be able to look up on your local court's website their recommendations for alternative dispute resolution. So what is alternative dispute resolution? Well, in short order, it's another opportunity to settle. It's another opportunity to negotiate. There are several bullet points there, some called settlement conferences, some called mediation, some called arbitration. They're all variations on the same process, which is that the court always says to two parties who are coming to the court to potentially have a judge decide their case, before the judge decides your case, we recommend that you go out into the hall and figure out a resolution on your own. And that process doesn't need to wait to go to court to do it, though there are usually opportunities to do it when you arrive at court. You can start that process early on at any time from the moment you receive the summons. You can go to these references. You can look it up on your court's website. You can call the recommended numbers and approach your lender to resolve this case before it goes to trial by negotiating under the guidance and jurisdiction of the court or a mediator or an arbitrator or a retired judge or neutral attorney for a settlement conference. The point is that even once you are sued, you still have the opportunity to negotiate and the opportunity to settle.